Good afternoon, everyone. It's my pleasure to be here with you today. I want to thank Sil Zalkan, who couldn't be here with us, and her amazing team at AC&J for this partnership. I have to continue to give a shout out to the 500 plus childcare leaders and directors who courageously opened their centers on April 1st to children of frontline staff and essential workers. In the development of these webinars, we lean to you for examples of practice. In a number of cases, the emergency program directors decided with their staff to remain open. It wasn't just a director decision, and I think that says a lot about humanity. This is all very new, and we recognize that the rules are evolving and changing as we transition to a new normal. I want to do a very quick recap of our first two webinars. I'm in contact with providers every day, and in speaking with them, I realized how challenging this transition is for many of you. It's overwhelming, it's hard, and for some, it might be scary. You might be anxious, and I want to acknowledge those feelings because they are real. And that's okay. Remember that the governor said that centers can reopen on June 15th. He didn't say that they must reopen. Last week, we outlined the first 3 strategies for reopening. If you missed any of those sessions, I would encourage you to go to the AC&J or Programs for Parents website to view them. They have a wealth of information that you can use. In those 3 steps, 1 was to contact your parents to have conversations about reopening. Survey them to see which children by age will be returning and when. Once you complete that, you now have a sense of how many children need care by age and when they plan to return. Second, have a conversation with your staff. Check in with them to see how they are feeling. Are they ready to return to work? And are there things you can do to help them feel more comfortable? And then what supports can you provide to assist them in being successful? We also talked about what staff will need to be successful, and they would include mental health services that focus on their own emotional state, as well as strategies to support the resiliency of children they will care for. We talked about professional development around the new health and safety standards, PPE supplies, face masks, gloves, and resources to support staff. And what we learned over the course of the 2 first seminars is that the work of the staff will change. Temperature and health screening for staff and children are required. Enhanced cleaning of the center, classroom, toys, and equipment will be needed. Social distancing for children. Face masks required to be worn by staff. You now know how many children by age are returning and when. You know how many staff you need, and you now have a sense of how many staff are available to work. Do you have enough staff to care for the children and address the new requirements? If not, you may need to hire staff. What we heard from you during this session were a host of questions regarding staff and your role as an employer. We recognize that there are a number of scenarios to examine. Some programs have laid staff off and they are now collecting unemployment. Some programs continue to pay staff during this period and they are still active employees, although the center may be closed. We've heard about staff being furloughed and that staff hours may have been reduced from full-time to part-time. As usual, because of various funding streams that support childcare, directors have had to make the different decisions about staff. As a child care director, you may not have an HR department to assist you in sorting out regulations that impact both you and your employees. But no matter when you open, there are things that you have to consider, and the purpose of today's session is to help you think about the reopening strategies that impact staff and help you move through the process. I want to add that you are not alone. You have state officials and departments that are here to support you and other organizations. Our guest today will share resources with you to help you think through your specific situation. Your OOL inspector will be a great resource for you on some things staff related. You have your local child care resource and referral agency, and you have your colleagues. Your local CCR&Rs will be reaching out to you to help you along the way. Remember the slogan, we are all in this together. I encourage you to collaborate and share with each other as you move along this process. And lastly, the goal is for centers to reopen. Families and children need your services, and the economy cannot flourish without you. So with that, I'm going to turn the presentation over to Yarrow at this time.
Okay, thank you, Beverly. I think we have a slideshow, and I just want to make sure my connection is okay. Am I freezing? All right. Okay. All right, so good afternoon, everyone. It's possible that you've heard from me before, ACNJ. I'm happy to be here again. So I work at New Jersey Citizen Action. It's a statewide organization engaged in organizing and advocacy. And we provide a range of services from tax prep to financial coaching, first-time home buying, counseling, and more. I also work with the New Jersey Time to Care Coalition, and we advocate for workers to have access to paid time to care. And so that's what I'm mostly here to talk about. Next slide. I'm freezing on my connection, so I just want to make sure everything is okay. All right. So I'm going to be pretty brief, covering just a few topics related to leave taking during COVID-19 and beyond. And we want to highlight leave issues because during a pandemic and otherwise, it's really important that if someone, a worker, is sick, that they are able to stay home. But it's important to understand, to be able to take leave, you have to be on payroll. So for information related to the unemployment questions and bringing people back to payroll after being laid off, Amy is going to cover that shortly. And I know there's a lot of questions related to that. So what I'm going to review is leave that workers may be entitled to under law and paid leave, which may help them afford to take leave. There are a few federal laws that are new related to COVID-19 and state laws that require paid leave related to COVID-19, but not necessarily related exclusively either. And then we're going to go over new workplace anti-discrimination and job protection, and just regular job protection that isn't exclusive to COVID. So please go to the next slide. So to begin, the new COVID-19 federal law, often called the Families First Coronavirus Response Act, which is the official name. So for short, we say FFCRA. It essentially has two parts related to leave. I'm combining here in one slide: emergency paid sick leave and emergency child care leave, which is sometimes called emergency FMLA, or family medical leave expansion. For emergency paid leave, workers are eligible immediately. But for emergency child care FMLA leave, workers must have been on payroll at least 30 days prior to leave. And it may not be available if the employee has already exhausted regular FMLA leave. And I want to just clarify, you're probably already aware, but I should mention that regular FMLA provides 12 unpaid weeks of leave, which covers eligible employees. So that's employees that have at least worked for a year and earned a certain number of hours. And at businesses with 50 or more workers, and it's for them to take leave for their own health, the care of a seriously ill family member, and to bond with a new baby. And it's been around for over 25 years. So that's not what we're talking about, but that is an important component to keep in mind. So the new federal COVID-19 leave laws just became effective this April 1st and will expire December 31st of this year. So the new FFCRA, workers can take paid leave for kids' school closures for both the paid sick days portion of the law, which provides 80-hour leave, which provides 10 weeks. Workers can also access the 80 hours for reasons related to COVID-19 that are listed here, but it's really anything related to diagnosis or treatment or recovery for themselves or to care for their family members. And in a second, I'm going, are we live? All right, I'm gonna keep going. I'm not sure, but in a second I'm gonna.
Yarrow, Catherine, you're actually doing great. Keep going.
Oh, I just saw a message about rebooting, so I was confused. Thanks for the clarification. I'm going to show you a chart in just a second to make the distinction more clear. So for the FFCRA, both of these programs cover workers at businesses with less than 500 employees. But for small employers with less than 50, they may qualify for an exemption from the 10 weeks or the emergency childcare leave, which is just to provide paid leave for school or daycare closings so that the worker can continue to care for the child, since the childcare is regularly not available. But it has to be, for the exemption, the leave payments must jeopardize the viability of the business. So small employers do still have to provide the 80 hours as part of the emergency paid sick leave portion. The employer must pay workers at their regular rate unless it's for caring for others or watching children when the school or childcare is unavailable, and that is payable at 2/3. And you can see on the slide there are daily and cumulative caps for what the employer has to pay. And a really important component is that the employer receives 100% payroll tax credit, plus any of the expenses related to healthcare, and also employer's share of Medicare tax on the leave. You can find more of the details about the tax credit on the IRS website, but tax credit reimbursement is supposed to be quick and easy to obtain, and an immediate dollar-for-dollar tax offset against payroll taxes is supposed to be provided, and where a refund is owed, the IRS is supposed to send it as quickly as possible. So just very quickly, regarding some of the details around what it means to access leave options when childcare is unavailable. The law says paid leave to care for a child under 18 years of age whose school or childcare provider is closed or unavailable for reasons related to COVID-19. So as you know, capacity for camp and daycare is going to be limited. And if the worker's child cannot enter the camp or daycare because of the limited capacity, that's gonna be included and covered. So not just for closures. Also, childcare provider can be anyone who cares for the worker's child. So that could be individuals paid, like nannies, au pairs, babysitters, and individuals who provide childcare at no cost. So grandparents, aunts, uncles, or neighbors as well. So next slide. Hold on. Sorry, okay. So you can see the distinction between the two parts in the next slide on this chart of the federal FFCRA law here. So just to make the distinction more clear. So the reason for the leave under the emergency paid sick leave 80 hours is for your own health, could be quarantining, could be your doctor is saying that you need to take time out to care for a loved one, and then also to care for a child whose school or child care is unavailable. So that's the 80 hours that applies to everyone with under 500 employees. And then for the 10 weeks, the emergency child care portion, that's only to care for someone, a child or son who is unable to go to school or camp or receive care by their regular child care provider. And you can see the distinction between how you would pay those wages. Employers, so below this chart is a link to the notice that employers are required to provide workers about these laws. The employer is required to post the notice, but they can also email or direct mail this notice to employees or put it on a website or some sort of communication. So basically, to request the time, employees should put in a simple written request to take leave to care for their child. They should provide the date they wish to take leave, the child's name and age, the name of their regular school, camp, place of care, or their child care provider that is closed or is unavailable, and then write a statement that no other suitable place or person is available to care for the child, okay? There's no sort of other application process, so to speak. It's the U.S. Department of Labor's Wage and Hour Division that has the authority to investigate and enforce compliance with the FFCRA. Okay, so we're going to go ahead and move off of the federal leave in the next slide. And we're going to cover the state paid leave law. So hopefully you're familiar with this relatively new New Jersey state earned sick leave law. It's been in effect since October of 2018. It requires that employers of all sizes provide all staff, full-time, part-time, temporary, regardless of immigration status, with at least 40 hours or 5 paid sick days a year. The employer can require that workers earn this time, or it can be provided upfront. If you earn it, it's 30 hours that you work, you earn 1 hour. So the permitted uses are here for your own health. Could also be preventative healthcare needs, caring for a loved one's own health, including preventative care needs, issues related to domestic or sexual violence, and then this is important, of course, for work or school closures because of a public health emergency or an epidemic, right? And they actually amended the law recently to include reasons related to isolation or quarantine recommended by a provider or public health official as a result of suspected exposure to a communicable disease. Also to care for a family member under the same advice. Next slide. Basically, you pay the employee the regular rate. There is no reimbursement, right? That is only in the federal law. For more details, you can visit the New Jersey Department of Labor's website. You can see mysickdays.nj.gov. The landing page is on the left here. And the notice that employers must provide employees is on the right. Sorry, I got them mixed up. And this includes accrual. The notice must include these details: accrual and use of leave, the right to file a complaint and be free from retaliation, and has to provide a benefit year. It's available in English and other languages on the website. Just so you're aware, not paying sick days is actually a form of wage theft, and that is a protective law for workers, and employers can face fines if they are found in violation. But before I come off of paid sick days and go to the next slide, I didn't create a separate slide about this, but I just want to mention that New Jersey also has 2 partially wage replacement paid leave programs for workers, the New Jersey Temporary Disability and Family Leave Insurance programs. It's important to just be aware, most workers are eligible for these programs if they've worked at least 20 weeks, earning $200 in those 20 weeks, or $10,000 in any covered New Jersey employer in approximately the year and a half before taking leave. So this is important in cases of longer leave of absence. So you apply to the state to access the partial wage replacement. And it could include instances where a worker needs to take longer than the 5 days provided under the earned sick leave law. It could be related to COVID or not. If the worker has an underlying health condition and their medical care provider certifies that they're unable to work due to the increased risk to their health, they may be eligible for this partial wage replacement. For temporary disability, it's available for 26 weeks. And for family leave insurance, which covers caring for loved ones who the medical care provider says is unable to work, it covers just currently 6 weeks, but it will be increasing come July. And the wage replacement is 2/3 until July. It goes up to 85%. So just important to know, as long as a medical care provider certifies the disability to the state, someone should be able to access the partial paid leave. The employer only contributes to the disability fund and doesn't have to contribute at all in taxes to the family leave insurance portion. And they don't have to do anything. The worker themselves applies to the Department of Labor. They have to, of course, notify the employer, and it isn't about job protection. This is just about them being able to receive wages while they're unable to work. Okay, the next slide. So this is about anti-discrimination and job protection specifically related to COVID-19. On the left, you can see this new notice or flyer from the Department of Labor. This is about the law that Murphy signed on March 20th that said during the current public health and state of emergency, employers are prohibited from terminating, refusing to reinstate, or punish an employee if they request or take time off for a reason for a specific period of time based on a recommendation from a medical professional stating that the employee has or is likely to have an infectious disease, COVID-19. The law covers all employees, but not independent contractors. And if a position has been filled, the employer is supposed to reinstate the employee to an equivalent position. Now, if you aren't recalling all your employees and the person you're not recalling has COVID-19, that shouldn't be a concern, but it's something to be aware of. On the right, in New Jersey, there's a law we have that's called the Law Against Discrimination. This is a flyer that talks about those protections, and it covers all sizes of employers. It's basically that employers cannot discriminate against employees because of actual or perceived race, national origin, religion, disability, and other characteristics, but it also does include pregnancy and breastfeeding. These same anti-discrimination protections now apply if the conduct at issue stems from concerns related to COVID-19. So this is a new change. So just be aware, you are not able to fire a worker because they coughed at work and you suspect they have COVID-19. That is a protection for employers that may be a little more unscrupulous than you all, so just be aware. So in New Jersey, we also have the New Jersey Family Leave Act, or FLA, and employers with 30 or more employees are subject to the law, which protects eligible workers' jobs if they are covered for caring for seriously ill loved ones or bonding with a new child. So this is the job protection aspect. When I was talking about the wage replacement, this is different. This is about if the employee the employer is obligated to provide the employee their job back. I'm going to talk about it in a second, but just related to COVID-19, Murphy did sign changes to that law that expanded it to protect eligible workers unable to work because of the impact of COVID-19 on a loved one. So that would include if the loved one has COVID-19 or is in isolation or quarantine because of suspected exposure to COVID-19, and if a worker's child's school or place of care is closed or unavailable because of COVID-19. An employer can request certification of the reason for the leave. Employers with 30 or more employees are subject to the FLA, okay? The employee does have to have worked 1,000 hours and been there at least a year to be covered. So the next slide, I just mentioned the Family Leave Act and how it's expanded, but I just want to remind you that it also covers workers regardless of COVID-19, as long as you have 30 employees. And it protects their job for 12 weeks for caring for a seriously ill loved one and bonding with a new child, okay? And this chart on the right, I'm not gonna get into, but what it does is tries to make sense and distill down for you the difference between the regular wage replacement laws, not related to COVID-19 necessarily, but it could, and the job protection. So you can see in orange in this chart is the wage replacement program I mentioned, temporary disability insurance and family leave insurance, and then the job protection, which is separate but can overlap and guarantee the worker their job back under both FMLA and the New Jersey Family Leave Act. And what complicates all that is, of course, the enhancements around COVID-19 that I talked about earlier. So I'm sure there's lots of questions, but I want to go ahead and give Amy a lot of time to cover her section since there's a lot of important topics that she's going to review, and we can hold questions till the end, I think, right? So it's next slide, and Amy, take it away.